Good morning, and welcome to the third and final presentation in our Filice webinar series, Technology and Your Benefit Plan, a New Twist on Group Health Plan Compliance. My name is Deborah Hyde, and I'm a risk counsel here at Filice Insurance. I'm also joined this morning by Tasha Merritt, who is our Director of HR Services. During today's presentation, we are going to first take a look at the role technology can play in a group health plan and managing group health plan compliance. Specifically, we're going to examine some of the advantages of using an automated system and then how the use of a system might impact the employer's role as a fiduciary to the plan. Next, we'll cover a few different compliance points that we think deserve special attention in the context of using an online system. We'll discuss enrollments and terminations, record retention rules, electronic distribution rules, HIPAA privacy and security laws, and the Affordable Care Act. Finally, we will address audience questions with the time that we have remaining. So before we get started, I want to take just a minute to cover a few housekeeping items. This morning's presentation should last right around 30 minutes, and you can feel free to submit a question at any time during the presentation, and you can do that by using the Q&A widget that's located at the bottom of your screen. Also located at the bottom of the screen is a link to our website, filice.com. So if you'd like to take a look at the other compliance publications we make available and download some of those, please feel free to do so. And then lastly, we will be sending out a PDF of the PowerPoint presentation this morning to every attendee. All right, so let's start off with examining the role of technology in group health plan compliance. So the use of an online system in group health plan administration provides invaluable advantages to compliance management. So an online system can provide automation, efficiency, and consistency. A system, it can automate many features of compliance administration, such as tracking employee eligibility or employee elections. And this automation means that you can use your time more efficiently. It frees up your time, it frees up your resources. Automation also means that compliance administration will be much more consistent. So your rules and processes related to benefits admin will be applied to each scenario in the exact same way. So you won't need to worry as much about one situation being handled slightly different than another because the system is going to be applying those rules and policies consistently. An online system also provides easy access to data and reduces the need for physical storage space. So all your relevant documentation and forms can be stored in one single location, accessible to anyone who needs it. And of course, this cuts down on the amount of paper files that are taking up space around your office and that you're trying to keep track of. An online platform will also most often come with vendor support and educational resources. So a really top-notch vendor should be providing you with an account management team. And this account management team will be accessible to you and available to you to help answer questions. And they will also help manage some aspects of your group health plan compliance. So they won't be responsible for it, but they will help you in administering that. Other vendors also provide clients with educational tools. These often come in the form of electronic or email newsletters or webinars. And this is just really another resource to have when it comes to your compliance strategy. And finally, an online system can synchronize your benefits administration and your HR management. So not all platforms will have the functionality to support HR management, nor will every employer necessarily want or need that. But for those that do, syncing benefits management with HR administration can be a really efficient solution that reduces errors or inconsistencies between your benefits and HR processes. So with all of these really wonderful advantages that an online system can provide, you might be thinking that your role as your role in group health plan compliance can be diminished or decreased somewhat but I'm urging you not to fall into that trap, because as the employer, you remain a fiduciary to the plan regardless of your use of an online system. So who exactly is a plan fiduciary? A fiduciary is one who exercises discretion over the management or administration of the plan. So the employer is always going to be the sponsor of a group health plan. And 9 times out of 10, the employer is also acting as the administrator. So this means that as the employer, you are always a fiduciary to your group health plan. And some fiduciary duties can be delegated to service providers and vendors, such as the vendor of an online system. But that delegation does not result in a transfer of fiduciary status. So your vendor of the online system is not going to become a fiduciary to the plan. What does this mean for the employer then? It means that you are on the hook for any administrative mistakes or oversights or missteps that might occur, and you can't get away with just pointing the finger at your system vendor. So there are some steps that an employer should take when using an online system. First and foremost, make a reasonable and informed selection of a vendor. So do your homework up front and make sure that the vendor you choose and you ultimately choose to use for your administration processes is reputable and is knowledgeable. You'll also need to exercise consistent oversight of the system. You don't want to go through the implementation process and get the system up and running and then just check out. You need to continue to be as involved as ever in all aspects of group health plan compliance. And there are a few specific areas where employers may be particularly vulnerable when using an online system. And these are areas that you may need to think about differently and approach them a little bit differently in light of the fact that you're using an online system, or they might even be areas of compliance that you need to address for the very first time. So I will hand it off to Tasha now to start us on that discussion.
Thank you, Deborah. The first compliance vulnerability that we are going to cover would be those vulnerabilities as they relate to plan enrollments and terminations. Dependent eligibility is definitely a subtopic of this that should be reviewed. In using an online system, you want to ensure that you have a uniform approach to requiring proof of dependent eligibility. Be conscious of how you're handling dependent eligibility verifications within your online platform. Whether the practice was already in place prior to the implementation of any online platform or not, you want to make sure that your practice is consistent and that your company practices aren't being handled in a manner that would be or could be deemed as discriminatory. Also, consider the process of requesting and reviewing dependent eligibility documentation in the context of a self-service model. So will dependent eligibility documentation be requested automatically from the system? Will you be alerted that dependent verification is necessary for those employees that aren't just enrolling as employee-only elections? Both are very important pieces that should be considered to ensure your compliance in using this online system. Next is waivers. All of your eligible employees should either have a valid election form on file or a valid waiver of benefits on file. A waive reason is not a required piece of this, but the ability for you as the employer to pull waive reasons from your online platform for analysis is something that could be helpful when you're discussing your benefit plan strategy with your broker down the road. So it's definitely something that we think you may want to consider requesting from those employees who are waiving your benefits plan. Mid-year election changes. Have consistency parameters in place for those employees who are requesting changes outside of an open enrollment. For example, for your employees who either give birth or maybe experience a divorce, you're going to want to ensure that if your system doesn't have parameters in place to only allow those employees to add or drop dependents according to their qualifying event, that you as the employer have a mechanism in place to catch any additional changes those employees may have made that they weren't eligible to make at that time. Leaves of absence is another area that should be considered in regards to plan enrollments and terminations. Some systems have the ability to help determine and track eligibility for a state or federally provided leave of absence, and some may not. So for those employers who are not subject to leave laws or regulations that mandate benefit continuation, you want to be sure you have a policy in place to determine benefit eligibility while an employee is out on leave of absence. Also, you want to consider that different leave laws may have different notice requirements when it comes to terminating coverage. For example, FMLA requires 15 days advance notice when you're terminating an employee from your plan. Also, you're going to want to establish expectations for employee contributions before the employee goes out on leave. Although this is a requirement for most state and federally provided leaves of absence, it's also what we consider to be a best practice for any employer-provided leave policies, so that there's no confusion as to things like how much the employee contribution is while they're out on leave, what type of payment you'll accept as the employer, who the payment is due to, and when the payment is due by. The next is going to be COBRA. Participants who experience a loss of eligibility shouldn't be kept in the system as an active participant or an employee. In the case of COBRA eligibility, the online system will not integrate with your COBRA TPA in most cases, so you as the employer will be responsible for providing notice of COBRA qualifying events within the required time frame. You want to determine your administrative process for ensuring that your COBRA TPA is alerted of any qualifying events in enough time to ensure timely notification to the affected individual. Although you may have a COBRA TPA in place that handles these notifications for you, ultimately that responsibility falls on you as the employer. The next compliance vulnerability to consider is ensuring that you're meeting record retention guidelines. Employers are legally obligated to record and preserve specified information that pertains to an individual's employment with the company. There's no requirement, though, that those records are hard copy documents, but if you're going to store them electronically, the Department of Labor's final rules relating to the usage of electronic communication and record-keeping technologies have guidelines on housing soft copy versions of these records, and that's what should be followed by any employer. If you're going to maintain your employee records electronically, you need to make sure that your system has reasonable controls to ensure integrity, accuracy, authenticity, and reliability. Also, that the documents are maintained in a reasonable order, in a safe and accessible place, and are readily available for inspection. Also, that the documents need to be readily available for conversion into a legible and readable paper copy. And lastly, adequate records management practices need to be established. Also consider, when it comes to record retention, the privacy and security of each file and who within the organization should have access. Your records may need to be segregated based on content and restricted access. So you want to ensure that your managers don't have access to things like employee medical records or other employee records that could cause a biased employment decision to be made. Ensure that you're also able to remove the files and take them with you should you move to a new system. Any information that's housed in the system should be retrievable by you as the employer, typically through an Excel extract, but you're going to want to ensure that the records you're required to maintain on your employees won't be stuck in a system that you are no longer using. Finally, consider the required length of retention for your personal records. Generally, employment records should be retained for the duration of employment plus 4 years. It's a little different with your group health plan and retirement plans. Those records need to be maintained for 6 years or 1 year following plan termination. And now I will give it back to Deborah to finish the rest of the presentation.
Okay, so a really amazing aspect of using an online system is just how quick and easy participant communication can become. So instead of printing out hundreds and hundreds of pages of notices and plan documents and handing those out to participants, you can now just post these notices to your online platform and make them accessible to every participant of your plan. So the U.S. Department of Labor also recognizes this great advantage, and they speak directly to the use of electronic distribution. So the general rule put forth by the DOL is that required notices and plan materials may be distributed electronically to employee participants who have regular work-related computer access as part of their job. So these are employees who are most likely going to be in the office and who use a computer regularly as part of their job function. So on the other hand, employees without such access, they must provide express signed consent in order for you to utilize electronic distribution. And the provision of employee consent is totally optional, and the employee has the ability to withhold that consent. And without consent, employees must be provided with hard copies of all required and relevant notices. So you need to look at your employee population and make sure that you have any necessary consent before you rely on e-distribution as your sole method of providing these required documents to your participants. So without appropriate consent, the Department of Labor will just by default consider the distribution to not have occurred. So you don't want to find yourself in a position where you're relying solely on e-distribution and you have a large employee population who doesn't have access to a computer as part of their work function and didn't sign off on consent for you to do so. You'll also want to consider distributions to your non-employee participants. So these are going to be your COBRA participants, perhaps particular spouses or dependents, and they will also need to be able to access these materials. A lot of systems do have options for making documents and notices available to non-employees. So in other words, not everyone needs to have a valid login and password in order to access those materials, but you do want to make sure that the system you have has that option and that it's effective and being used. So using an online system really brings to the forefront HIPAA privacy and security rules, particularly as those rules relate to electronic protected health information, or EPHI. So protected health information is individually identifiable information that relates to either the medical treatment or diagnosis or payment for care. And electronic PHI, of course, is just PHI that's kept in an electronic form. So depending on your level of involvement in plan administration, your access to PHI or ePHI may be pretty low, but you can be certain that your vendor is likely handling some form or another of ePHI and that you are transmitting that data to them. So you need to be certain that the system vendor you contract with has in place adequate policies and procedures to handle and to store ePHI. So we talked about ePHI being stored in the system and that perhaps the extent to that may depend on the vendor and the platform that you use, but regardless, the vendor must comply with HIPAA by safeguarding PHI, protecting against unauthorized disclosure, and of course, providing notification upon a breach. So if there was an unauthorized disclosure or a breach of access to that ePHI, they need to have protocol in place of how they're going to notify you. You'll need to consider the vendor's internal security measures and HIPAA policies for handling client data. So ask about it up front. They will likely be willing to provide you with either a copy of their policies and procedures or maybe some of the steps they take for data storage. So if you ask about it, they should be prepared to provide you with some sort of confirmation that they're taking those right steps. Also be certain that you're entering into a business associate agreement with the vendor. So under HIPAA, the group health plan, or in this case the employer, must enter into a business associate agreement with vendors who have access to PHI. So a business associate agreement will detail the responsibilities of the vendor to protect PHI and their obligations to alert the employer of any unauthorized disclosure. So be absolutely certain that you have a business associate agreement in place with the vendor before you start providing them with that data. So last but certainly not least is the Affordable Care Act. And the ACA brings an entirely new level of complexity to compliance management. And the right online system can really go a long way in helping you manage those particular areas. But pay attention to how the system handles a few different aspects of ACA compliance. And the first of those is going to be eligibility determinations. So if you have non-full-time employees, you need to be sure that your system is tracking those variable hours and that you have appropriate measurement and stability periods in place. A lot of systems are built with parameters to make sure that you don't overextend measurement periods or stability periods. They're kind of built in with those parameters, but you still need to make sure that what the system has in as its rule and what it is applying to your employees is consistent with the policy that you've set up and that you've communicated. Also think about your new hires and how they're being classified and put into the system. Are they going in as full-time employees when they should be variable, or are they going in as variable when they should be going in as full-time? Pay attention to how the system is classifying your new hires. And then, of course, you have waiting period limitations. So, the Affordable Care Act limits employers to a 90-day waiting period, an exact 90-day waiting period. And again, a lot of systems will have the parameters set so that you cannot exceed 90 days, but you do need to be certain that what you've set up and what you've established in your plan as the waiting period is the same as what the system is applying. Another point to watch out for is the affordability calculation that needs to be done. And the affordability component of the Affordable Care Act, of course, it only applies to those applicable large employers. So it may not apply to you, but if it does, you need to think about how the system is making the determination of affordability. So if you have a system that integrates both payroll and benefits, then you can be pretty certain that the system is checking your contribution strategy and the cost of benefits with the employee's rate of pay and making the calculation and determination of affordability. But if you don't have integrated payroll information, you either will need to be supplying that to your vendor, or you may have to make that calculation and determination yourself. So make sure you understand what that is and make sure that you're inputting appropriate data to reflect the affordability of your contributions. And then finally, perhaps the biggest piece of ACA compliance that a system can go a long way in helping you with is the annual IRS reporting under Section 6055 and 6056. So this again is going to come down to whether or not you have your payroll and your benefits data housed within your system. If you've got an HRIS system or an integrated system where your payroll and your benefits can speak to one another, then your reporting is likely going to be pretty automated in the sense that you won't have to supply or manually input a lot of data. But if you have separate systems, you will need to be responsible for manually inputting or providing that payroll information to your vendor so that they can carry out the reporting. And again, that might be an area where some errors or inconsistencies can pop up, so be certain that you're auditing that and providing accurate information. Also think about accurate coding. So if you've been through the reporting process already for 2015, you're well aware that the ACA forms that you need to complete the reporting on require you to use a set of specifically designed and created ACA codes. And these codes can be kind of complex, but don't rely on the system to make all of those coding decisions for you. You want to be involved in that process. You want to audit the codes that the system is assigning to your employees and make sure that the codes are accurate and that they accurately reflect the type of coverage that you provided and the time that you provided it. And then lastly, the method in place to distribute forms to employees and submit the forms to the IRS. It seems pretty simple, but you still need to be involved and you still need to do some work beforehand. So the first is your method to distribute to employees. Is the system vendor going to be mailing out hard copies to employees? Are they going to be utilizing electronic delivery of the forms? Or is it going to fall on you to provide the forms to your employees? Have that sorted out up front so there are no surprises and you're not left at the end close to the deadline scrambling to figure out who's doing what and how. Also ask about submission to the IRS. A lot of vendors will default to electronic submission to the IRS. Of course, electronic submission is required if the employer is filing 250 or more forms. So it might be required that you file electronically, it might not be, but regardless, if your vendor is going to provide electronic submission, make sure that the vendor is set up to do so. So, electronic submission is not an easy process. The vendor needs to prepare beforehand and prepare with the IRS to carry out those submissions. So ask about that upfront. Ask if they're ready to go, ready with the system to submit these forms electronically. Again, you don't want to be stuck close to the deadline and find out that your vendor is having issues with the electronic submittal. With all of these topics in mind, there are some common themes that you could apply to your technology compliance management regardless of the specific issue. So first is play an active role in the administration process. Do not adopt a hands-off approach. You want to stay as involved as you've ever been. The capacity of your involvement might change a little bit, your role might change a little bit, but your level of involvement should stay the same. Monitor the system's ongoing efficacy. So check frequently to make sure that the data within the system is accurate, the data you're supplying is accurate, and then be sure that the rules or parameters that you've established in the system are correct. You don't want to have inconsistencies between the system and your policies. Stay educated on relevant laws and regulations, whether federal, state, or local. Your system is not going to provide you with updates on regulatory changes, and they won't be able to tell you how a specific law applies to you or affects your plan. You need to be aware of those things and make those determinations yourself. And then, of course, audit your internal policies and procedures to ensure consistency with the online system. So you may need to amend or update some of your policies to make sure that you're operating in sync with your system. So things that you might want to look at are your open enrollment policies, your eligibility rules, and probably your data privacy and protection policies that you have in place for your plan and for your company. Make sure that those recognize the fact that you're using an online system now.
Thank you, Deborah. We hope that you all found today's presentation helpful. Before we get to attendee questions, we just want to remind everyone that we have upcoming vendor demos for different online systems. The week of Tuesday, May 3rd, the participating vendors are ADP, eCentral, Paycom, Paylocity, and PlanSource. Details about each demo and registration links are going to be provided to everyone who attended today's presentation via email. These demos are the perfect opportunity for any employer who's maybe entertaining the idea of implementing an online platform or wanting to switch from one to another to kind of get a better idea of what capabilities each system brings to the table. Here at Filice, offering our employer groups with support surrounding online enrollment platforms has really become a core item in our service offering. Our staff is fully equipped to assist with determining which platform might be the best fit for your organization, implementation of an online platform, all the way down to providing compliance support when you're using your online system. And now we will go ahead and get to some of the questions that have been submitted throughout the presentation. Let's see.
Okay, so how can an online system be used for participant notices if no employee has work access to a computer? So this is a really great question. It's something that you want to think about when you select a system and when you choose to kind of go on to the online enrollment route. You can still use an online system for your benefit notices, but you need to make sure that you're getting that consent. So first and foremost, provide the opportunity for your employees to give consent to electronic distribution. Most often, employees do prefer electronic distribution just like you do and for the same reasons that you do. Nobody wants to try to keep track of tons and tons of paper. So you might be surprised with the number of employees who say, yes, I really do want you to utilize electronic distribution for all these notices. But you might still have some who would rather receive hard copies and who withhold that consent. And again, that's totally fine. That's their option. Just make sure that those employees are getting hard copies of every single notice. You don't want to end up neglecting them, number one. And also some employers tend to strike a compromise in a sense by saying, okay, well, instead of providing you all with your own copies, your own hard copies, I'm just going to make a big binder of all these copies available in the HR office, or I'm going to make a computer kiosk available for employees to use. That doesn't cut it. The DOL has actually made that very clear in their final rule regarding e-distribution. You won't be able to strike that compromise. You're either going to be utilizing electronic delivery or providing hard copies.
Another question, do we have to require proof of dependent eligibility? No, that is not a requirement. Employers typically do require proof just to make sure that they aren't covering any ineligible dependents. If you do require proof of dependent eligibility, you just want to make sure that you have a consistent practice in place, and you want to make your employees aware well ahead of time of what proof is acceptable. And if you don't, then you can occasionally conduct dependent eligibility audits to make sure that you aren't covering any ineligible dependents.
Okay, and one final question we have a minute for. What if your broker manages the system for you? Are you still responsible for errors? The answer is yes. You are still responsible for the administration of your group plan and for doing so correctly. So first of all, it would be surprising if a broker actually managed the entire system for you. There's a lot that your broker doesn't know or have access to that relates to your group health plan administration. So you should still have a management role when it comes to your online system. Your broker should be in more of a supportive role. But yes, even if your broker was managing the entire thing for you, you are still a fiduciary of the plan. Your broker does not by default become a fiduciary of the plan. So you're still responsible and you're still on the hook ultimately for anything that could go wrong with your group plan administration. So that looks like all the time we have for this morning. If you have questions after the presentation at any time, please feel free to reach out to either Tasha or myself at our email addresses listed there. We love to take your questions and provide you with some more information surrounding compliance and technology. Thank you so much for joining us this morning and for joining us throughout our webinar series in the past 3 weeks, and have a wonderful rest of your day.